boleh yang Amat Arif jelaskan mengapa permohonan cerai di bawah Seksyen 47 UUKI tidak melalui penyerahan borang 6 dan akaun berkaitan seperti yang diperuntukkan. Situasi ini menyumbang kepada si isteri perlu berulang-alik ke Mahkamah Syariah untuk tuntutan nafkah, edah, harta, sepencarian, muta'ah dan sebagainya. Terima kasih.
I think the question, Ya Arif, is why can't it all be done together at one point semasa talak, and then like in the civil non-Muslim in the civil division is all in one petition, whereas for Sharia it's various proceedings have to be filed.
I think it can take place. Two situations may arise, Liza. See, there are quite a number of cases as well where, especially the wife, they want to settle the divorce first. They want to get rid of the husband, okay, and berjuang untuk benda-benda yang lain tu another day. So because they want to get rid, they want to get rid. The sooner the better. So all the other ancillary matters, okay, will be filed later on. So we have that situation. So if we were to combine all the ancillary claims, okay, and tie it with divorce, for example, that will always be used by the husband to drag the matters. Okay,
untuk mempercepatkan dan meringankan cerai tersebutlah.
Ya, betul Liza. So these are the yang kadang-kadang yang agak dilema lah. How we want to make sure, okay, that the parties can resolve the matters amicably. Aisyah, Liza, remember tak when I mentioned about the philosophy, so we hope that the husband, okay, when they want to exercise the talak, they must make sure that all the rights must be recorded at the same time. This is what we call ma'ruf and also ihsan. So in other words, whenever that you want to pronounce talak, then all the rights of the wife must also be taken into consideration. That if you want to be a good husband, you cerai dengan ma'ruf dan dengan cara yang ihsan. Ihsan I already explained. Ihsan means the husband, when he pronounces talak, he must also ensure that all the ancillary rights of the wife is also given. Tapi benda tu kadang-kadang ideal tu Liza. Not everybody can exercise it. I hope. So I cakap tu dalam ni kan. Tapi berapa banyak yang so many Quranic injunctions yang orang pergi langgar semua. Dia duit. Kadang-kadang the personal interest overrides everything. So this is the predicament that we have. As far as the Sharia courts are concerned, we know that many wives, they want to settle their status first. This is what they require from the court. They don't mind if other matters can they file it later on, as long as their status with the husband can be determined by the court in the first place. Sebab itulah Liza, Aisyah, dalam konteks ni bila you tanya dengan I, kedudukan dia kenapa yang kita ada di Mahkamah Syariah tu yang kita tak combine. Ada yang kita combine bersekali. Okay, kalau all the parties they come to Syariah court, they agree, all the ancillary matters are also consented by the husband, then we don't have any problem to record them. But in many cases, okay, many wives, they know they had discussion, or the lawyers had discussion with the husband lawyers, but the husband lawyers will use the ancillary, the husband may use, I'm talking to the lawyers, I'm so sorry. The husband will use the ancillary matters to drag or delay the divorce punya application. Itu yang so we need to strike the balance between the two.
Kalau ada, okay, if we have proof yang wife tu, isteri tu sleeping with another man, at the same time both husband and wife agree to the divorce, or they want to get the divorce, what right has the wife have in terms of the plea of no shoes?
Custody,
Nafkah custody in terms of the husband might say no shoes against her, kan?
Okay.
Yang Arif,
Aisyah, Section 59, Clause 2 clearly provides whenever there is an allegation of recalcitrant in the part of the husband or the wife, okay, then in the interest of justice, the party who alleges nushuz on the part of the wife, he needs to prove before the court. It is very important. Because there is a misunderstanding, Aisyah. Many wives who do not aware of their rights, they thought that whenever the husband declares them to be nushuz, then they are so worried. While in law, the law clearly says it must be the declaration whether the wife is actually has committed nushuz or become a recalcitrant is only the court third party can decide. Okay, this is what I need to explain so that we understand the real position of nushuz. So in other words, Aisyah, for as long as there is no Sharia court judge who has officially pronounced or declared the wife to be nushuz or recalcitrant, she remains a good wife. So if the husband, truly says, that she has actually slept with another person, so I want the court to declare, then he has to bring the matter before the court. This is what I'm saying. So kalau selagi tidak ada mahkamah yang declare the wife to be recalcitrant, then she would remain loyal and she is entitled. And we got to remember, Eliza, Section 59, the title of Section 59 is on the right of the wife to maintenance or nafkah. You can only find the word nushuz in that particular section. So in other words, there is a connection between nushuz being recalcitrant with her entitlement to nafkah only. So in other words, it may not affect the wife's right, for example, to custody of the children.
What about harta sepencarian, Ya Arif? So because just now you said nushuz relates to
same thing, Liza. Remember I said Section 59, there is the word nushuz. So harta sepencarian is under Section 122. You look at Section 122.
So it's not affected by the nushuz?
No, it is not, because harta sepencarian is defined as jointly acquired properties. It involves contribution by the wife, it involves contribution by the husband, to the acquisition of the properties. So the wife should not be denied of the rights to whatever that she has acquired, whatever that she has contributed, just because of the fact that she becomes a nushuz.
Someone from our parties overseas, they got married in Selangor, but they're both overseas now, and now they want to divorce, mutually agree. Is it possible for them to file the divorce application with help from friends and family without appointing Sharia lawyer with their case to be heard online?
Oh, I'm talking before lawyers, Okay.
It's okay.
Sure. I think one the steps that need to be taken by the parties is to, first of all, if their marriage, have not been registered, if they were married overseas and the marriage have not been registered in Malaysia, then they have to make sure that the marriage is registered first. So how are they going to register the marriage? Then he has to go through the Sharia courts, either under Section 12 Clause 2 or under Section 40 Clause 2 or Section 23 Clause 2. The law requires for them to register their marriage before the Sharia court. So then the Sharia court, once the Sharia court has already issued an order for the marriage to be registered, then they will bring the order to the pejabat agama, then the pejabat agama will then issue a marriage certificate. And with that marriage certificate, Aisyah, then they will file an application for divorce. For as long as the marriage which has not been registered by the parties, then the Sharia court will not have or assume jurisdiction, because Section 45, Clause 1, A, B, and C requires in order for the court to assume jurisdiction to dissolve a marriage, then the court must make sure that the marriages are registered. So registration of marriage is important. Once they have gone through and get the marriage certificate and then file an application for divorce, whether the first step to register the marriage or the second step to file an application for divorce, the parties are free at liberty whether they want to get Sharia lawyers representation, or they can represent themselves. There is no mandatory in the Sharia court them to be represented by parties.
But in this case, they are abroad, Yang Ma'arif. They are abroad. So what happens in that situation?
If they are abroad, Aisyah, we have I told you, there have been since April 2020. A lot of parties married husbands in Australia, for example, husband in Kuwait. We have cases where husband in the United States of America, the wife are Malaysians. They want to divorce during the PKP. Husband was stressed in America. A wife is more stressful in Malaysia. They agree. So the application was heard online. Now, this is what I'm saying, Liza. For as long as the parties have agreed for the application to be heard by the Sharia court judge online, then the court would not hesitate or will facilitate, the parties' request and wish, for the matter to be resolved amicably by way of online.
In this case, they just have to know who to contact lah. The people overseas, they have to know who to contact in the Sharia courts in Malaysia.
Yes, but make sure the steps, because when the question was posed to be, I'm not sure whether the marriage has already been registered or not.
It has been registered. They registered. Presumably they have registered. This is married in Selangor 10 years ago, and they're abroad now. Yeah.
Ya Arif, so let's move on to the next question. Boleh tak yang Amat Arif terangkan apakah beza talak 1, 2, 3 dan seterusnya jenis-jenis penceraian atau penceraian perkahwinan seperti fasakh, khuluk, especially taklek. Boleh tak yang Amat Arif terangkan jenis-jenis penceraian ini?
Talak 1, saya dah bacakan ayat tadi suratul Baqarah. Dalam suratul talak Allah SWT sebut at-talaqu marratani, maknanya talak tu 2 kali. Maknanya suami cerai lafaz talak hari ni dan 100 hari contohnya, suami lafazkan talak, kemudian isteri dalam keadaan isteri tu suci, kemudian isteri tu berada dalam keadaan haid, kemudian dia suci, suami tu lafaz yang kedua. So jadi maknanya dalam tempoh talak yang pertama tadi tu yang dilafazkan oleh suami tadi dan isteri tadi tu dia boleh rujuk. Talak yang pertama namanya dia ada hak untuk rujuk. Yang masa Aisyah tanya soalan tadi tu kan, dia boleh rujuk secara perkataan, suami kata saya rujuk kembali awak, dan kedua-duanya kembali sebagai suami isteri. Kemudian yang kali kedua suami dia lafaz talak lagi. Lafaz talak yang kedua, kemudian suami rujuk. Dalam tempoh 1 hari tu Kaliza, suami tu rujuk kembali. So itu dah jadi yang kedua. Suami masih boleh rujuk. Kemudian kali ketiga pula suami tu lafaz kali yang ketiga, dan kali yang ketiga tadi selepas daripada itu nama dia talak bain kubra. Maknanya selepas kali yang ketiga tadi tu suami tadi tu dah tidak boleh rujuk kepada isteri. Yang pertama, yang kedua boleh rujuk, yang ketiga tadi dah tak boleh rujuk. Itu namanya irrevocable. Ini namanya perceraian secara talak. Kemudian Liza tanya, apa lagi jenis-jenis perceraian lain yang boleh dipohon oleh isteri? Kita ada banyak tuan-tuan dan puan dalam undang-undang. Kita ada contohnya di bawah section tadi kita dah bincang, di bawah section 57, sekiranya suami tadi tu dah lafaz talak di luar mahkamah, isteri boleh filekan kes di bawah section 57 untuk mengesahkan perceraian tersebut. Ini cara yang kedua. Cara yang ketiga macam yang Liza sebut tadi tu, fasakh. Fasakh ni, this is what we call judicial dissolution of marriage because of certain reason. Ada grounds di situ. Berlainan dengan talak, fasakh ini adalah di bawah kuasa mahkamah. That's what we call the judicial separation. So the power is given to the judge. Is immaterial for as long as there is an allegation by the wife, for example. There is a cruelty, for example. Kalau ada keganasan rumah tangga, suami pukul isteri. This is one of the grounds. Yang ini diperuntukkan dalam section 53. Dalam section 53 tu Aisyah Liza, ada sebanyak tidak kurang daripada 19 alasan yang diperuntukkan dalam undang-undang. Cruelty tu is one of the 15 grounds yang ada dalam section 53. So contohnya kalau katakan suami tak bagi nafkah, suami kata dia berpelesiran, womanizer contohnya, suka tukar pasangan perempuan, sehingga menimbulkan emosi pada isteri tadi tu. Kalau isteri tadi tu dipukul, these are some of the grounds provided under section 53. If it is proven, then wife boleh, court akan dissolve the marriage dan perkahwinan tu dibatalkan secara fasakh. Okey? Kemudian ada taklik, Liza sebut taklik. That one is under section 50. Okey, cerai secara taklik. Cerai secara taklik ni adalah apabila suami telah melanggar perjanjian dia semasa perkahwinan. Kita sedia maklum semasa perkahwinan selepas akad nikah tu suami ada lafaz, dia berjanji. Dia kata dia tidak akan memudarat isteri dia, dia tidak akan gagal memberikan nafkah, dia tidak akan meninggalkan isteri dia selama lebih 4 bulan. Okey. So So ini adalah perjanjian suami. Jadi kalau suami itu meninggalkan isteri lebih pada 4 bulan, jadi isteri tadi tu boleh memfailkan di mahkamah syariah tuntutan di bawah taklik. Sebab apa? Sebab isteri tadi tu telah melanggar suami tadi tu telah melanggar perjanjian dia. Selain daripada itu Eliza Aisyah, isteri tadi tu juga boleh mohon khuluk. Khuluk ni adalah is by way of redemption. Isteri membayar mahar dan sejumlah wang kepada suami tadi tu sebagai balasan untuk suami tadi tu melafazkan talak. Tuan-tuan dan puan sekalian, sekiranya dia adalah secara khuluk, sekiranya dia adalah secara fasakh, kesan dia, Liza, adalah irrevocable. Nama dia bain. So in other words, if the court affects the divorce by way of fasakh under section 53, then it becomes irrevocable. So in other words, once the court has dissolved the marriage judicially, then the husband cannot simply revoke sebab dia dah jadi bain. Begitu juga kalau secara khuluk tadi. Dan juga Liza, kalau taklik Section 50, sekiranya dalam perjanjian suami isteri itu di hujungnya ada suami itu menyebut, dan apabila aku memberikan sejumlah RM1 atau RM10 kepada mahkamah, maka jatuhlah talak tu secara taklik khuluk. So it becomes khuluk because wife tadi tu serahkan RM1 dan RM10 kepada mahkamah, dan mahkamah simpan duit RM1 dan RM10 tadi tu. So taklik yang berbentuk macam tu, kemudian khuluk dan juga fasakh, tuan-tuan dan puan, it partakes the nature of irrevocable. Okay, you got to understand, it becomes irrevocable. Why? It becomes irrevocable because the husband will not have the right to revoke the divorce. Itu kesan dia. Okay Liza, so this are some of...
Tapi Arif, bolehkah mereka bernikah semula?
Ya, boleh Liza, dia boleh bernikah semula, okay, tetapi dengan akad yang baru. Okay, remember kalau katakan yang revoke tadi tu, there is no akad, there is no solemnization, there is no new mahar. When there is a new akad, then there is a new mahar given by the husband to the wife.